Hello, Colorado real estate investors and residents. Marc Cunningham with Grace Property Management here in Denver, Colorado. Want to share with you for a few minutes about a recently passed bill here in Colorado, HB 241098. Now, this bill, all 23 pages of it, is a massively impactful bill for residents and real estate investors, landlords in Colorado. It's going to change the landscape in a major, significant way in Colorado. So we just want to share a couple key points that you as a real estate investor or real estate agent or landlord in Colorado should be aware of to ensure that you're compliant with this bill. Now, the title of HB 241098 is called Concerning Protections for Residential Tenants and in Connection Therewith, Requiring Cause for the Eviction of a Residential Tenant. Now, you may want to just pause there and say, well, wait a minute. Are you telling me before this bill was passed, I as a landlord, as a real estate investor, I didn't need cause to evict my tenant? I could just go evict anytime I wanted, and that's not correct. One of the things that I think is a little bit disingenuous about this bill is it is redefining some terms which have always meant what we know them to mean. An eviction requires cause. Property management companies can't just go evict tenants for no cause, but this bill redefines what an eviction is, which we'll share here in just a minute. Couple pieces to be aware of specifically. Now, before we diagnose this bill, and we're just touching on a couple points, there's a lot in this bill, this 23 pages. It's very complex, very confusing, quite frankly. We've read through the bill numerous times. This is not a full analysis of the bill. We're just pointing out a couple highlights. Now, let me say, as a way of setting things properly here, we are not an attorneys. This is not legal advice. This is our interpretation of the bill as we are working through it to determine how operationally we will function underneath these new rules governing property management in Colorado. So a couple key points. Key point number one, rent demand notices served by landlords to tenants must now be served in the resident's preferred language. And it specifically says whatever language that is. You can imagine the logistical complexities of now having to go find out what your resident's preferred language is, and whether that is I'm not even going to guess languages, but whatever language it is, that notice has to be served in the tenant's preferred language. And if it's not served in the tenant's preferred language, that is cause to have the entire potential eviction case thrown out by an attorney. A lot is going into just this one little component of the bill to ensure that we're complying. And the landlords, you need to make sure that you're complying with all of this. Part one. Part two says this. Rent demand notices must now have 2 service attempts on 2 separate days before that demand notice can be posted on the door. So previously how things worked in Colorado is a demand notice for rent had to be physically served upon the property. Now, just that in and of itself is a little bit old-fashioned because most states have moved to make things more functional, and we're using technology so that notices can be delivered electronically, but not in Colorado, where they still want to see the notice physically served upon the property. Someone's got to get in their car, drive to the property, but they can't just post it upon the property any longer. They have to first make it an attempt at public service, knock on the door. If someone's over the age, I believe the bill says of 15, they can deliver it to them. If no one's there over the age of 15, they've got to leave, come back the next day, attempt another personal service, and if that person isn't there, then they can post it upon the property. Logistically, this is going to be very expensive for landlords to comply with, setting aside even the safety concerns of someone having to knock on the door and physically attempt to make contact. Probably not a wise thing to put into this bill, but we're not here to really make comments about the bill as much as I would like to. We're just sharing the nuances and the aspects of the things that we make sure property management companies and landlords are having to comply with. So if you have a demand notice, go to the property, attempt service. If it's not there, you wait 24 hours, wait till the next business day, you come back and attempt to reservice at that point in time. Number 3, this is where the bill gets very, very confusing, and it talks about an entirely different aspect. So previously, I just talked about notices have to be served in the tenant's language. Notices have to be served with 2 attempts. The bill also addresses, a big section of this bill, addresses the idea of non-renewal of a tenant's lease. So here's what it does, which I think this is kind of some of the disingenuousness of the bill. Because what this does is a lease non-renewal. Meaning, hey, Mr. Tenant, I'm going to sign a lease with you for 12 months, and at the end of the 12 months, the lease expires. So at the end of the 12 months, you need to move out of the lease because the lease term has expired. That's contract law 101. Well, no longer in Colorado, because now what this bill has done is it's redefined a non-renewal, which is just kind of understanding of, no, we're not going to offer you a renewal of the lease, Mr. Tenant. Now that is called a no-fault eviction. So I no longer will say, I'm not going to renew your lease. Now I have to say, I'm evicting you. I'm legally evicting you by no fault of your own. Now you can imagine just that in and of itself. That just sounds terrible, because a tenant who has been a great tenant, always paid their rent on time, and I, as the landlord, am not going to renew them because maybe the owner's moving back in, maybe I'm going to sell it. I now have to legally inform them that we're going to initiate a no-fault eviction on them. No fault of your own, but the legislature now requires me to evict you rather than just saying I'm not going to renew your lease agreement. Not a wise move, in our opinion. Not only that, but the landlord now must have cause to non-renew the tenant. This is a very different change psychologically. It's a very, very different change in contract law 101. We enter into a contract. When that contract expires, I, as the landlord, am now required by law to offer a renewal to you unless a few specific triggers have been made, in which case I don't have to offer you the non-renewal. So it requires me to offer a non-renewal, or requires me to offer a renewal to all of my tenants unless certain things happen. Now I'll share with you a couple of those certain things, but don't overlook this. So if you as a landlord are putting a tenant in place for a 12-month lease, you now are required by law to offer them a renewal of that lease unless one of these triggers are met. So it's now legally allowable to non-renew, meaning a no-fault eviction. So I can no-fault evict you if any of the following are true. Number one, I want to demolish the property. Doesn't really happen too often, but if I decide I want to tear down and demolish my property, I'm allowed legally to now non-renew your lease. Number two, if I want to convert the property to a non-residential use, I'm going to make it, which was a single-family home, and I'm going to convert it into an office, a commercial use. I can decide to no-fault evict you or non-renew you, which is the common terminology. If I want to convert that long-term rental to a short-term rental, which isn't really done in Colorado because of regulations around short-term rentals these days. If I want to move back into the property, I can non-renew you, but there is very, very specific requirements around that. There's a timeline of when I can move, when I have to move back into the property. Is it family members? And I can't legally change my mind or decide, no, I'm going to re-rent the property for a specific amount of time. I believe it's 90 days it says in there. So if I non-renew a tenant, move them out of the property because I'm going to be moving back into the property, and then for whatever reason I don't move back into the property, I can't put it back on the rental market for a certain amount of time. So you can see that that's just a small example, but this bill gets very, very nuanced and very, very difficult. Other reasons I can choose to non-renew my tenant when the lease does expire is if I decide to sell the property, and there are specific requirements around that as well. If there are substantial lease violations from the tenant, I can choose to non-renew, and it gets very, very granular on those lease violations. If the tenant has a history of non-payment of rent, and that also is not general, it doesn't just say that, it then has several paragraphs within this bill that define specifically what the non-payment has to be. It can't be, or it has to be at least 2 times, I believe, they have to be late, and more than 10 days late. Like, it gets very, very specific. They can't just be late one time or two times. They have to be late and meet the specific requirements of the bill. So late rent is too broad. It has to meet the specific requirements, very conditional that way. If I'm, as the landlord, am I going to make substantial repairs or improvements to the property? And that, again, there are several pages that talk about that. For example, if I'm going to make substantial improvements or repairs, I have to legally give the tenant the first right of refusal, so that once I've completed the repairs, I have to first be able to say to that tenant, do you want to re-rent this property? I made you move out. I didn't renew your lease because I had to make these substantial improvements. But before I can put it back on the rental market for anybody to rent, you have first option. Mr. Tenant, do you want to rent the property or not? And there's a lot of rules governing the timeline. When do I give them notice? How long do they have to decide? How long do they have to move in? It gets very complicated. And as you're reading it, it just, quite frankly, makes you shake your head and wonder how in the world they came up with some of these things they did, but they did. Further, a couple of other reasons I can choose to non-renew a tenant. If the tenant refuses to sign the new lease, but again, there are conditions there. The lease has to be It has to be reasonable. The terms have to be reasonable. And in all of these instances, so let's pretend I'm moving back into the house. I'm selling the house. I have a legitimate reason per the new law to non-renew my tenant. I'm required now, and you are required, to give them a 90-day notice. That's a big, big deal. I've got to give them a 90-day notice period. The notice has to be very, very specific in the things it says. So if it's selling, it has to say that. If there's repairs, it has to say what the repairs are going to be. It gets very complicated here. And then there's a whole nother part of the bill that talks about more and different rules for tenants in mobile home parks, which we're not even going to address right now. That's just a scratching the surface of this 23-page bill. Now you say, well, gosh, that's a lot of things to be aware of. How long do we have to prepare for this, Mark? Well, you have negative time to prepare for this. In clauses in Colorado, in laws, the legislature can choose to insert what they call a safety clause. A safety clause is this bill is so important, it's so urgent to protect the public safety and welfare that it immediately goes into effect upon the governor's signature. Safety clauses are not used a whole lot in the legislative bills unless the bill is just urgent. Well, our legislature has determined that this bill is urgent. The safety clause was triggered, and therefore it went into effect when the governor signed the bill. We're recording this video the end of April 2024, and this is in effect now. So that means if your tenant's lease expires tomorrow, and you were planning, or it expires next month, and you were going to give them a 30-day notice, which you could typically do because you wanted to sell the property, well, hold on. You can't do that. You're going to have to give them a 90-day notice, a new notice, and the notice is going to have to meet these new legal requirements to ensure compliance so that you can legally non-renew their lease, or as the new law says, you can no-fault evict your tenant. Now, this is going to cause evictions, of course, to skyrocket in Colorado because every non-renewal of a lease is now classified as an eviction. You can see a lot of problems with this. So that's just a scratching of the surface. Again, this is not legal advice, but if you're a client of Grace Property Management, know that we are doing this on your behalf. We are doing all of our due diligence along with our attorneys to ensure that we stay compliant and continue to represent you in the management of your property in a fair and accurate and transparent way for you and your tenant. If you're not a current client of Grace Property Management, please consider us a resource. If we can offer help, reach out to us. Jump on our website, rentgrace.com. Happy to help if we can. In the next couple months, we'll be dissecting multiple new laws that the legislature has passed, so you can make sure that you're watching for those. But until then, my friends, I wish you success.